Good morning. May it please the Court. Nathan Schultz, Greenberg Traurig, LLP, on behalf of the Appellee, Richard Sachs. Your Honors, as a preliminary matter, I'd like to thank you for your careful review of the briefing. This is a pretty tortured factual record, and it's clear that you've got a good mastery of it. I also wanted to note that lead opposing counsel in this matter throughout this case passed away in an accident last summer, and no disrespect to Mr. Arnold, but it's not quite the same not having Mr. Rankin here. But getting to the substance, I want to address any questions the Court has. I want to respond to some points that counsel made and highlight some important reasons why the Court should affirm the BAP's decision here. And we focused on it in an opening, but we're talking only about the element of intent to hinder, delay, or defraud under Section 727A2A of the Bankruptcy Code. That's what's at issue. There were 6 issues on appeal discussed in the opening brief, but there's really only one, which is intent. And there are 3 subparts to that. And so I would like to cover those things. The first one is, does the debtor's admitted purpose that she made the transfers to protect, so that's a quote from her testimony, those assets from a judgment creditor, does that constitute intent under Section 727A2A as a matter of law? The BAP found the answer is yes, and that's the right answer. The second question is, does the debtor's allegations that she made those transfers based on attorney advice, does it change that result? The answer is no. That's what the BAP found. That's the right answer. Third question.
Stop right there. Why?
Why is that the right answer?
No, yeah.
It's because...
No, you think it's the right answer, but why is it the
Sure.
right answer?
The case law supports why it's the right answer. The requirement is to rely on the attorney advice defense. It has to be in good faith. And this Court's decision in Adeli says what good faith means is that you didn't know that the purpose of the transfer was to hinder, delay, or defraud your creditors. As a matter of law, the debtor said here, I knew that what I was doing, and my attorneys told me to do it because the purpose was to keep this money away from Mr. Sachs. She knew what the purpose was. That takes it outside of the good faith attorney advice. People call it an exception. I'm not sure it's an exception. I think it's a question, it's a tool to decide, did she have the intent or not? And for example, I was thinking about this, and I thought, go ahead, John.
Does it make any difference? There's been a lot made about this potential that Mr. Sachs somehow might violate the court order. Does that make any difference?
No, it doesn't make any difference. And that's the central theme of, I think, the issues we should cover, which is it's playground wisdom. 2 wrongs don't make a right. Okay? If a debtor actually, let's assume a debtor actually had reason to believe, which Your Honors have hit on an important point. There's no evidence that Mr. Sachs would have done anything other than the debtor saying, subjectively, I was afraid that he would. But let's say there was even evidence that he might do something extrajudicially. Does that mean you should sanction the debtor to then also take the law into her own hands and transfer funds and act outside of the court system? That's not what the statute is designed to do. The statute is designed to disincentivize debtors from doing that and to incentivize them to make full disclosure and treat their assets not in a way of obscuring them and trying to hide things, but to be above board about it. So the answer to someone even legitimately fearing that someone's going to act extrajudicially is to go into court and get relief for that. And they had a stay in place that said he couldn't execute on his judgment, and she had counsel. This isn't even a pro se debtor where you might say, well, she wasn't advised, she had no recourse, there was an economic justification. Whether any of those things would be good enough isn't before the court, but none of them are present here. She had counsel. They told her to do it. She knew the purpose. She made a decision at that point. She could either follow the advice of counsel and do something that was designed to thwart somebody that had a judgment against her, or she could not. She decided to do that. You can't go back later and say, well, because an attorney told me to do it, therefore I don't get blamed for that, if you knew what was happening. And what I was going to say is that I sat around for a while and tried to think, when would the good faith exception apply? Is this just an empty, because hardly any of the cases talk about it applying. The one Ninth Circuit case from 1936, case that did apply it, was a case where the attorney said, there's a trust here and there are assets there, and those aren't subject to execution by your creditors. They're not really your property. They're outside of the sphere of anything a creditor might get access to, so you can do what you need to do with them. So the purpose of the transfer there wasn't to protect the asset from anybody. The debtor had some other, I don't think the opinion discusses it, but some other purpose for it. Here's another example. The debtor gets some tax advice, and the tax advice says, for tax purposes, transfer these assets into a trust or into an LLC. And that happens to happen shortly before a bankruptcy case. The bankruptcy case is filed and someone says, look, you transferred the assets. Your purpose was to hinder or delay your creditors. I think there the debtor goes and says, look, the purpose was not to do that. I relied in good faith on my attorney advice, and my attorney's advice didn't say transfer these so your creditors can't get them. The attorney advice said transfer these because it's tax benefits. That's a good faith attorney advice.
Well, in the first instance, the example that you gave from the old Ninth Circuit case,
yeah.
The assets wouldn't be part of the estate.
Right, exactly. And so the purpose wasn't to hinder a creditor because a creditor could never get them.
You said there were 3 reasons. I kind of interrupted you on number 2, so.
3 reasons. And the third one is the Adeli case, the disclose and recover exception. And the court correctly noted that, number 1, applying that to a voluntary case is dicta. So whether it even applies in a voluntary case is dicta. We don't have a ruling from this court that says disclose and recover applies. But even if it did, again, go to the purpose of Adeli. Adeli is really, I view it as a policy case. It says, even though the statute doesn't say transferred and remain transferred, we're going to read it that way because the whole point of the statute is to encourage debtors to do the right thing or to discourage them from doing the wrong thing. It goes back to 2 wrongs don't make a right. And in that case, the debtor did something wrong. He transferred things, and he knew the purpose was to harm his creditors. But then he got some good advice. And the good advice said, this is a mistake. You got a problem. And what the debtor decided to do was to try to rectify it, to right the wrong. He tried to put everything back. He got interrupted in the middle, so he couldn't complete it. And the court was very clear that you had to find that if you were interrupted in the middle, that you were trying to rectify it and that you completed that full rectification shortly after, you were involuntarily thrown into bankruptcy. Here, this debtor didn't rectify or even try to rectify the wrong. The wrong was transferring the $208,000, keeping it in a friend's name. There were 2 accounts, and Your Honors are exactly right. One of them, she had check writing privileges on, so she was just writing checks for things. The other one, she went to the friend and asked for the money. Partway through that, $100,000 of that went into another account, her business account. She continued to spend that money. And that business account is important because what happened is the case filed, and there's this stuff about Mr. Brent. He asked for it. They got lost. It came back. The timing. I think counsel's right that the BAP made a very small, and I don't think it's a material error in finding that there was something on her part that should be imputed and considered reflective of her intent that the money didn't go to the trustee until May. Because he's right. Debtor in possession is the equivalent of a fiduciary, and Mr. Brent kept that money to the side at all times. I don't think that's evidence of anything. But what is that money in the corporation bank account, the $100,000 that came from the original $200,000, she never disclosed that when she filed the case. So number 1, you have a disclosure violation.
Didn't she disclose to Brent, though, about that money, about the original transfers?
Sure, she did.
She may not have told him where it was, but she told him about the transfers.
Absolutely, but the standard isn't did she disclose it to her own attorney so that they could try to figure out what's the narrow, exact right way to keep the benefit of the transfer but also not get hit for discharge. Brent said when he heard about that, this stinks. This is not good. But he said, I think your best bet in terms of whether you get nailed for it or not is to keep the money here. That's not trying to rectify the situation.
Suppose he would have been, he says he wasn't familiar with the deed, but suppose had he been familiar with the deed, he would have said, well, here's what we got.
Yeah.
You better get all that money back here before we file.
And I think the bankruptcy court found that...
What would be wrong with it? I mean, why.
Sure, and look, he might have. The problem is, that didn't happen. We're talking about supposition here.
Well, she says she would have done that.
Sure.
Had she been properly advised.
And we don't know what would have happened at that point. Sachs might have been able to levy sooner. It might have forced her into bankruptcy sooner. There might have been a better recovery for the estate. The bottom line is there's no entitlement to the Adib defense. The Adib defense is all about let's encourage people to do the right thing. If someone's trying to do the right thing, we shouldn't penalize them. She didn't go to Mr. Brent and say, hey, how can I make this right for my creditors? I think I might have done something wrong. Can I fix it? What she said was, I think I might have done something wrong. How can I not get in trouble for it? Am I going to get in trouble for it? What do I need to do? The focus, it's even in the briefing. She was trying to preserve her discharge, which of course she would, because that's the biggest issue in a bankruptcy case is, do you get discharged or not? And it's a severe penalty for the court to take that away. And it only happens if you do something that's clearly not appropriate. And the statute is very clear on that. And so she was trying to preserve that ability. She wasn't trying to make things right for creditors. If she was trying to make things right for creditors, number one, when she filed the bankruptcy case, she could have told the whole truth instead of little bits and pieces of it. Two, if she was trying to make things right for creditors, she could have taken the money back from the corporation bank account, put it into the bankruptcy estate the way that she got back the $38,000. And on that $38,000, let's remember one point. They tell the story about Mr. Brent asked for the money, the checks were lost, it came back. One of those accounts, she had check writing privileges. She didn't need to ask anybody for it. She could have written a check to the bankruptcy estate herself. She didn't do it. There wasn't a manifested desire here to make creditors whole. It just doesn't fall within a deed, even if a deed applies in voluntary cases. This isn't the kind of behavior that you want to incentivize debtors to do. You don't want to incentivize them to take matters into their own hands, point their fingers at their attorney, even when they knew what was going on. This tells people, go prophylactically, talk to an attorney about everything that you are going to do that you think is bad, and then you can shield yourself with it later. That's not the intent behind the issue. I think I've covered the three things that I wanted to cover. I'd close with, there's the disclose and recover exception. This isn't a disclose and recover case. It's a hide and spend case. And the fact that what the assets were spent on happened to include some living expenses doesn't tell the whole story. There was a $40,000 pension that was funded that was later recovered. This debtor got some bad legal advice, but there's no question she took matters into her own hands. There's no grounds here to reverse that.
Just out of curiosity,
Sure.
has Sachs recovered anything?
Absolutely nothing today. There's a Chapter 7 proceeding that's about to be wound up. I expect that there will be some distribution from that. I don't know how much it'll be. But as of today, he's recovered $0 on his judgment.
So his only hope is to preserve his claim.
Right. He has a pending state court litigation that against her has been stayed that he would resume and seek to execute on his judgment. There are other claims in addition to the one that he got the judgment on.
So the second transfers, as far as you're concerned, really aren't that critical because what you're looking to do is to preserve the denial of discharge.
Well, the second transfers, I think, are additional evidence and additional grounds to deny it, but you only need one. And the first ones, I will readily admit, are the most compelling ones. I think there's a host of transfers that could each alone serve. In fact, I should correct one thing I said. He got $4,500 in July of 2005, 3 months before she filed, 2 months before she filed the case. There was one bank account where she forgot and left a little bit of money in there. He got that. He got $4,500.
But he had a $750,000 judgment.
Yes, the $727 was the face amount of the judgment.
Well, that was $727.
Yeah, it happens to be the same number as the statute, which is a strange coincidence. Thank you, Your Honor, for your time.